India has witnessed a multitude of historical trials that have evolved and made our constitution a personification of justice, fairness, and good conscience. One of the lawsuits that have broadened the horizon of the meaning of fundamental rights was D.K. Basu versus State of West Bengal. Hello everyone, in today's video, I'll be explaining you about one of the landmark judgment, that is D.K. Basu versus State of West Bengal. The case was headed by the Division Bench of Supreme Court of India, Justice Kuldeep Singh and Justice A.S. Anand. Our main objective is to understand Section 176 of Criminal Procedure Code, which was applied in this case, that is, inquiry done by the magistrate in the cause of death. Secondly, constitutional provisions, that is Article 21, right to life and personal liberty, Article 22, that is arrest and detention in certain cases, and Article 20, Clause 3, that is an accused shall not be compelled to be a witness against himself, were also used. Facts. In this case, Mr. D.K. Basu, the Executive Chairman of Legal Aid Services, wrote a letter to Chief Justice of India to raise concern over the matter of recent deaths and custodial violence. In the letter, it was mentioned that the crime reported goes unpunished despite of many efforts made, and also that court needs to analyze and issue raised so that family members of the victim are given some compensation in the acquittance of their suffering. The letter was treated as a writ petition when it was filed before the Supreme Court of India. Shri Ashok Kumar Johari addressed the letter to the Chief Justice of India by highlighting the death of a person named Mahesh Bihari of Aligarh in police custody. On 14th August 1987, the court issued the order to all the state governments, and notice was also issued to the Law Commission requesting appropriate suggestions within a 2-month period. In response to the notification, several states submitted affidavits. Additionally, Dr. A.M. Singh, Principal Counsel, was appointed amicus curiae to assess the court. Legal issues. Why there is a growth in crimes against persons in custody? Are policemen arbitrary in arresting a person? Who is responsible or answerable for custodial torture and deaths by police? Or is there any need to specify some guidelines to make an arrest? Contentions of petitioner. There rose concern over the police powers and that compensation should be given to people if there is any infringement of their rights mentioned in Article 21 and 22 of the Constitution. Contentions of respondent. The counsel representing different states and Dr. A.M. Singhvi presented the case and stated that everything was fine within their respective states. They presented their respective beliefs and provided useful assistance to this court. The defendant, that is the state of West Bengal, stated that the writ petition was misconceived, inappropriate and misleading in law, and thus denied the allegations which were put against them. After examination of various facets of problem, the counsel was of the opinion that court should formulate the guidelines to reduce, if not prevent, violence in custody, and compensation should be provided to the relatives of those who die in custody due to torture. In this case, 11 guidelines adhering to Article 21 and 22 Clause 1 were prescribed by the court, which need to be strictly followed, otherwise the official would be liable to be punished for the contempt of court and proceedings must be instituted against him. So the first guideline is, the police personnel carrying out the arrest and handling the interrogation of the arrestee should have clear identification and name tags with their designations. Second, the police personnel carrying out the arrest shall make a memo at the time of arrest. Third, the person who has been arrested shall be entitled to have a friend, relative, or any person known to him that he has been arrested or detained at the particular place. Fourth, the time, place of arrest and venue of custody of an arrestee must be notified by the police, and where the friend or relative of arrestee lives outside town, through the legal aid organization within a period of 8 to 12 hours after the arrest. Next, the arrest person must be aware of his right to inform someone of his arrest. An entry should be made in which there should be a name of person in custody, his friend who has been informed, and details of police officials. 7th, the arrestee should be examined at the time of arrest, and injuries on his body must be recorded. The inspection memo must be signed both by the arrestee and the police officer concerned, and copy must be provided to the arrestee. 9th, copies of all the documents, including the memo of arrest, should be sent to the magistrate for his record. 10th, the arrestee must be permitted to meet his lawyer during the interrogation but not throughout the whole interrogation. Lastly, a police control room should be provided at all district and state headquarters where information regarding the arrest and place of custody of the arrestee shall be communicated by the officer causing the arrest within 12 hours of effecting the arrest and should be displayed on the notice board of the police control room. The court was of the opinion that custodial violence, including torture and death in lockups, strikes at the rule of law. Custodial violence, including torture and death in prisons, was considered by the court to be one of the worst crimes in a civilized society governed by the rule of law. Reference was made to the case of Neelabati Behera vs. State of Odisha 1993, in which the Supreme Court had held that prisoners and detainees are not deprived of their fundamental rights under Article 21, and only restrictions permitted by law could be imposed on the enjoyment of fundamental rights of prisoners and detained. The case thus gave a landmark judgment where guidelines regarding the arrest of a person were prescribed. Otherwise, more offences were committed in the name of doing justice. It prevents any infringement with the rights of an individual during detention and thus protects all the citizens by certain procedures established by law. The case also debated that attention of the Parliament should be invited to the need of amendment of statutory provisions in the view of sharp rise in the custodial violence and for the amendment of relevant provisions of law to protect the interests of persons accused. Therefore, more strict laws should be made so that innocent people have not to suffer. A profession where you have the power to kill should be a profession that requires highly trained officers who are accountable to the public. Our police forces have been accountable only to the politician in office. If now we want them to be accountable to the people, then it's we the people who have to hold them to account. Thank you.